Good afternoon, ladies and gentlemen. I'm Shelley Stokes Hammond. I'm the Development and Public Affairs Officer for Howard University Libraries, and I would like to welcome you to the Spring Author Talks and Book Signing Series sponsored by the staff of Howard University Libraries, the Friends of the Library for Howard University, and Sister Space and Books Bookstore. Today you will enjoy the first in our series, and to welcome our distinguished author, I would like to introduce you to the Director of Howard University Libraries, Mr. Maude McCowie.
Thank you, Shelley. Good afternoon, ladies and gentlemen, again. On behalf of the Howard University Libraries, I want to welcome you to this special event this afternoon in Founders Library. We are privileged and honored to listen today to Dr. Mary Frances Berry, a most distinguished person with an illustrious career as history and law professor, as chair of the U.S. Commission on Civil Rights, as senior university official, and as author of many books and other publications. You'll find in the literature you received on arrival the specifics of her illustrious career in public service, higher education, and scholarship. Our president, Mr. H. Patrick Swigert, and Mrs. Sonia Swigert, chair of the Friends of the University Libraries, are unable to be with us this afternoon. But they do extend their best regards to Dr. Berry, our honoree, and to you, friends of Howard University, on this special occasion. Now, ladies and gentlemen, I would like to respectfully invite Dr. Berry to the podium for her insightful and enlightening talk on the Pig's Farmer's Daughter and Other Tales of American Justice. Dr. Berry.
Thank you. Thank you very much. Thank you. Thank you very much. It's always so good to be back on the campus of Howard University. I went around in some of the rooms to look at the things that were carved on the walls and on the desks when I was here before, many of which are gone, but there are a few left from when I was an undergraduate. Although many things have been modernized at the university, we can find a few little initials here and there if we look very carefully. And thank you so much for coming out to this session. The Pig Farmer's Daughter is not me. I'm not the daughter of a pig farmer. People say to me, isn't this your memoir? And Mary Frances, I knew a lot about you, but I didn't know you were a pig farmer's daughter. But the book begins this way. When I was 4, I had my first encounter with the law. And this encounter came at the early age of 4 when I was playing with my young cousins about my age in a field next to the house of my mother's middle brother, and his family. And my many Southall cousins played ball there to while away the lazy summer days, and the older cousins were supposed to be watching us while we were playing. And one afternoon while we were out there, a uniformed man, a white man, on a motorcycle rode into the field, kicking up a cloud of dust. He rode up to us youngsters and he called out as we were watching the ball game, "What day is this?" And one of the little kids answered, "Monday." And then we scattered in all directions when suddenly the man on the motorcycle drove at us, yelling angrily, "Call me Mr. Monday." And then he raced away up the road. And to be sure, we cried. We didn't know what was going on or what this was about, so we were crying, and our older cousins came and gathered us up in their arms, and I remember one of them told us, "Now that man is a police officer." That's what they call a police officer. And that was my first knowledge of what a police officer was that man. And he said that man likes to go around the black community harassing people. He thinks it's funny. So you stop crying. And what that means is that it took me for years so that every time I would see a uniformed police officer coming up to me, all I could see in my mind's eye was Mr. Mundy on that Nashville summer's day. Now that's my story about the law from an early age. And this story, of course, has a rich history dating from the days of slavery, when any white person had the authority to stop a slave, to ask for a pass or correct a slave, or a white man on slave patrol could even kill a slave at his discretion. We know that story from white cappers and night riders and the Klan, and the punishment of those who were prospering economically or seemed uppity. And this tradition of keeping African Americans in their place through the awful and unpredictable power of the white man to harass and abuse at any time, supported by the community and the legal system. So this was the reality that was imprinted on my mind at an early age. And imprinted also from that one encounter was what years of teaching about the law and worrying about the law has only reinforced. The law has the force of violence, and the law can be irrational and prickly in the hands of its enforcers. But I now know that everyone has stories, including lawyers and judges and jurors. Stories provide a frame of reference and which determines what we believe is true about the law. They shape the law and how the law is enforced. And the stories of African Americans like me and my cousins, our cultural frame of reference has rarely prevailed, not our stories. William Pickens described this in 1933, how the stories of those in control dictate legal results. That great quote of his, which we used before in long memory when John Blassingame and I wrote it, says, for generations in this country, when a Negro came into court facing a white opponent, he had to settle not only the question involved in the charge against him, but also all the traditional charges against his race. In fact, the whole race question. Like Socrates before his accusers, he had to face a jury which was influenced not only by the evidence, but also by the, quote, evidence that had been taught to them in their infancy, in their growing up, in literature, taverns, shops, and from a million other sources. Everybody's got a story. And whose story counts in legal decisions rests heavily on who controls political and economic power. Who controls, who is silenced, and who controls. And only in recent years have African Americans served on juries, been able to testify freely, been admitted to leading law schools, published in major law reviews, are served on state and federal courts. Hearing and responding to African American stories is a radically new experience for many people. And I'll tell you one other story here from my own lifetime as a child, which I think will explain how complex this problem is. It is a story about class and race, racial paternalism. One of my uncles was a scamp. He loved to tease and poke fun and play rough with his children and all of my cousins. And when we were little kids, he would throw us up in the air and catch us, and he would do all kinds of things. And he sometimes would playfully pinch us so hard that we would cry almost. But he always had jokes to tell and pockets filled with an endless supply of candy kisses. So we loved him. But he worked very hard all week, and then on the weekend, he'd get drunk. And he'd go out and he'd party and he'd get drunk and he'd end up fighting with somebody, and then he would be in jail. So every Saturday night, my aunt had to call around to all the jails to see if she could find him. And always, once she found him, she would call up his wealthy white employer, one of the wealthiest men in town, and say, he's in jail, what do we do? And the man would say, where? And he would call down and tell the sheriff, I say, I understand you've got my boy there again. Well, once he sleeps it off, let him out, because he's one of the best workers you can find. Now, my uncle also fit within a historical tradition. The first time I told this story about him to someone, they said, well, gee, the people there, they must really have loved black people. That's why they let your uncle out of jail. He fit within a historical tradition, the protection given the valuable black slave by his master, he could only be killed, even if he had an offense of some kind, with his master's complicity, and if officials compensated the master. After slavery, paternalism still played a role. For example, African Americans could gain release on parole in the late 19th century very easily if some white person expressed interest in using them. I've looked at many letters which were sent to parole officials saying, I can use a Negro full-time. I understand the state is letting out persons on parole, and there's a Negro there named G. Send him over to me. And off he would go. Now, everybody has a story. Now, remember that courts are like a theater. When you think about a court, think of a theater. In the halls of the court, we hear the stories that the officers of the court tell. They have a role to play. Those of judges and prosecutors and defense attorneys, and these stories are shaped by thousands of years of common law tradition and by intense professional training. They are the stories of an educated elite, but they're still stories. There are other actors in the court, too, with very different stories. The jurors, middle class, working class, male, female, black, white, yellow, red, all have their own stories. So do the police and the social workers and the victims and those who stand accused. All of these people represent a variety of classes and colors. What that means is that the courts are an intense and dramatic microcosm of American society, in which issues of life and death often hang in the balance. If we still doubt what I mean by stories and their importance, consider just briefly the O.J. Simpson case, which we've heard a lot about and maybe too much about, but let me tell you what it means in terms of stories. What happened is you had one jury in the first case that saw the case according to the stories they knew and told to each other. And what they had historical memory and a present reality of was police who tamper and invent evidence, or people like Officer Mundy, whose name probably really was Monday or Tuesday. It depended on what day it was and when he asked you, who set up situations to harass people, or to convict people, or to justify assault on people. Their stories included all of that. So that was the jury which found reasons to acquit. And then you've got stories again in the civil jury, where people had stories of police officers who are wonderful people, who are guardians and who are fair and who would never invent anything or harass anybody. So everybody had different stories. They saw the world differently. Now, this is not just about race. It is about race and gender and class and sexuality, and sometimes the three all converge. But let me give you an example of how gendered frame of reference determine verdicts and stories of gender. There was this case over in Baltimore in the 1990s in which a judge was sentencing a man who killed his wife because he found her in bed with another man. And the jury convicted him. The judge, though, was very upset by this. He thought that there ought to be a short sentence, but it should be as short as possible, because he sympathized with the defendant because he could not think of a circumstance whereby personal rage is uncontrollable, greater than this for someone who is happily married. He had a story about women and about men and about marriage and about what was permissible. And his story included the wife is not supposed to be in bed with this man, and if she is, kill her. That was his story. And he did not want to convict this guy. So he gave him this low sentence. He said something else in the case. There's nobody here in the courtroom to notice what I did, so nobody will ever hear about this. And nobody will ever claim that I did the wrong thing. He said that openly on the bench. Well, he was mistaken because somebody was there and they reported it to the news and it ended up being on the news. And then there were all these people who organized to say, your story is not our story. Now, she might have been doing whatever she was doing, but that doesn't mean you need to kill her. And there were protests, and people filed a complaint against him with the State Judicial Commission saying that this guy ought to be kicked off the bench for misbehavior. Now, to show you how complex this is, the commission that considered the issue had 7 members, and there were 3 women. Now, if it were simple, you would assume that the 3 women would decide that the guy should be kicked off the court. If you didn't know anything about Clarence Thomas and other people, you would assume that the guy should be kicked. They would all say he should be kicked off the court. No. 2 of the women on the commission said he should be kicked off. But one of them just said, well, he's just doing what judges are supposed to do, and he's making up his own mind. And I can see why, you know, he should feel like this man should be upset. And the man went on and was still on the bench. The main thing is that if you want to change the law, you have to understand the impact of stories on how it operates. If you think the law is just some black letters written down somewhere, some rules, then you never will be able to change it. I'll give you an example of how some people tried to change the law and then nothing happened. Women's groups got together to change the law on rape so that women who charged rape in a trial couldn't be asked about their prior sexual experiences. They thought that if they did that, then that means more people would come forward to complain, the trials would be fairer, and that people would be willing, so they wouldn't be exposed, and maybe there would be more convictions, because the story about women being loose women and being promiscuous and maybe inviting the rape and so on wouldn't get in. The law was changed. They enacted rape shield laws in almost every community, saying that you cannot enter into evidence or even ask the woman about her prior sexual experiences. You know what happened? The judges just continued to go ahead and let people ask anyway. How did they get around it? They would say, instead of asking, who did you go out with and did you have sex with somebody, they would say, well, where were you on the night of February 20th? And who did you go out with? And where did you go? And how long did you stay? And on and on and on and on and on, over and over again, so that the same kind, and that was because the judges had their own views, their own stories about how women should behave and who should do what, and stories of gender, and they used these stories in order to come up with the results that they came up with. And so when people try to counter old stories, they're old stories, and what you're trying to do is change the stories to include some more stories so that you can get a new story that will be fair. That's what we're trying to do. We see it on every kind of issue, everything from gay and lesbian anti-discrimination law, which is in fact reinforced by old stories, to everything else that happened. In the gay community, they try to do something to change the story that African Americans have done historically. It's called the politics of respectability, that Melinda Shadavere and in her book on the women of the Brotherhood of Sleeping Car Porters, and Evelyn Brooks Higginbottom in her book write about. The gays and lesbians argue that we're just like everybody else and we have families, and so we should be treated like everybody else. And it's the same argument that suffragists use to get the vote for women, that if we vote, we'll just vote like our husbands, so don't be scared, let us vote. Okay, that was the argument. The politics of respectability among African Americans after slavery was the idea that if we self-consciously adopted white middle-class values, we would end discrimination and negative images of African Americans. This culture of respectability still exists. It's seen in African Americans, including my mother, who will not go to the grocery store, even if they're on vacation, before they dress up like they're on their way to church, a business appointment. They got to have the whole deal, from girdle to hat, gloves, the whole thing. Because the whole idea is that if you dress like that and go to the store, everybody will treat you better, and you're respectable. So you shouldn't just run out, even if you're on vacation. Take you an hour to get ready to go to the grocery store to get some milk. Okay, and this strategy, of course, does not always work. And the use of such a strategy by gays and lesbians risks silencing those for whom homosexuality is an alternative lifestyle, which may include casual sexual contact with no committed relationships. In effect, what they're doing is marginalizing and silencing the story of those who are not like this politics of respectability that they are trying to advance, in the sense of making new stories that will change the law. Now, I'll give you one other example of how this plays out in reality before I tell you about the pig farmer's daughter. The pig farmer's daughter. If you will consider, for example, the story of Clarence Thomas and his elevation to the U.S. Supreme Court. you will see the importance of stories. The facts were shaped into this Pinpoint, Georgia story, which is the town he was from, down in Pinpoint, which the Bush administration put out. It read pretty much like one of those Horatio Alger stories of the poor boy who makes good in America. And it began with him being born in this poverty-stricken town, and it was a publicist's dream, delivered by a midwife to a teenage mother, living in a 5-room board house without a toilet or a telephone. Before he was 2, his father abandoned the family. His mother supported the children by picking crab meat for 5 cents a pound. Boy, they were hungry and poor and everything else. But the story left out the fact that he had gone to live with his grandparents in Savannah and that he grew up in the home of his maternal grandfather, who was a well-off businessman. That wasn't part of the story. The story highlighted his attendance at a now-closed Roman Catholic school for black children run by white nuns, and told about how he was a bright student, an altar boy, a patrol boy, an athlete who still contributes money to help the nuns, and he was seen on national television choking back tears as he thanked the nuns shortly after his nomination to the court. This was all part of the story. Then there was the incident when we were told he dropped out of seminary, where he was training to be a priest, seminary preparatory school, because of anger when Martin Luther King was assassinated. Left out of the story is the abbot of the seminary, the preparatory school seminary, said that he recollected nothing of the kind. All he remembered is that Thomas just felt like he didn't want to be a priest. That's all he remembered about it. But that was ignored as a deviation from the storyline. The narrative talks about all the rest of his negotiating elite institutions and so on. It was a particularly attractive story to white Americans whose European immigrant grandfathers struggled, like his grandfather, to achieve the American dream. And what happened there is that Thomas's old, very old story, his rags to riches story, was infinitely more acceptable than Anita Hill's feminist story of sexual harassment of a black woman. This meant that white and black men could share in rejecting her claims, and she could go and be consigned to whatever she was consigned to, and relatively unscathed, he could take his place as a lifetime Supreme Court justice. It just shows the importance of how we look at things and the importance of stories. Now, let me tell you about the pig farmer's daughter story, which is very instructive. As I was looking to find cases that had not been used before, and many not even known about, rather than making up stories, to see how the law is shaped and what happens, I noticed this case of a black man being accused of lynching, being accused of raping a white woman in the late 19th century South in Texas. And of course, given the history of that period, we all know about the lynchings that had taken place and all the false claims of rape and charges of rape and black men being lynched and some women for being uppity and so on. So I fully expected him to be lynched. So all I did was turn the pages waiting for the man to be lynched. So I kept turning the page. Well, he'll be lynched on the next page and then on the next page, and I'm going along and he wasn't lynched. And so then he was taken to jail. Still wasn't lynched. So I said, well, they'll break in the jail now and tear up everything and take him out and lynch him. And then they didn't do that. So then I said, I noticed there was a trial and he had a lawyer of all things. And very few people could afford to have lawyers. And then the jury met and they still hadn't lynched him, and he's actually in the courtroom. And the jury, which had 12 white male jurors there, convicted him. So I said, well, they were just waiting to convict him, so surely now they will take him out and lynch him. Turn the page, oh no. He is appealing with his lawyer to the state Supreme Court. He appeals to the state Supreme Court, and it consists of ex-Confederates who are on that court, elite judges from that state, and they overturned his conviction. And he went home and went on about his business. Now the question was, how could this happen, you know? And so I'm looking very carefully and searching, because I've already made up my mind what was going to happen, and it didn't. And I discovered through reading the trial record and the appellate opinions, the justices said, we noticed that some of the most prominent people in the community testified for this man as character witnesses. In fact, he worked for the most prominent, richest white man in that community. And this man testified and said he was a good Negro. And he was essentially wanted him back at work. And so then we decided to look to see who this woman was who was claiming that he had raped her. My, she's nothing but a poor pig farmer's daughter. Essentially, they defined her as poor white trash and defined him as what? This white man's boy. As surely as my Uncle Lincoln, or my uncle, the one I was telling you about, was the boy of the man who called up to get him out of jail every time he got drunk, this guy was the boy of his employer and was a good Negro. And certainly the stories, let's think about whose stories got told there. The story that got told, the black man's story didn't get told. Nobody was interested in his story. Her story really didn't get told. They weren't interested in her story either. The only story they were interested in was the story of white male privilege. That's the story they were interested in. Elites like them who said, let's do this, and this is what we want to do. In other words, the man was an object to be acted upon. She essentially was an object to be acted upon. Whose stories counted in this particular case? And when I say white male privilege, I hasten to add, not every white male is privileged. You know, Joe Sixpack and Joe Lunchbox is not privileged. But I'm saying that the group of people who, in fact, were making these decisions were making decisions about what they want to do. It's much like the case I talk about in the book much earlier than that, where a man is having an affair with a former slave woman, Sally, Mr. Turner is, and his wife comes home early from visiting the neighbors and finds them in flagrante delicto together. And the wife is very upset and has the nerve to speak to her husband about this. And her husband tells her it's none of her business, basically. And then not only does he do that, as they continue this relationship, however it was going, and the wife would complain every now and then, he one day sent Sally, the black woman, out to get some switches to come back to whip the wife to make her shut up, and told her that if she'd not shut up, she would be corrected and stop interfering with his business. And the wife filed for divorce. And the court was not interested in his relationship with Sally. As a matter of fact, they said, this is not a matter of concern. It is of no concern. I mean, after all, we know about Thomas Jefferson and Sally Hemings and other people whose names we don't know. The court of these privileged white men like he was, they didn't care how many black women he had, you know, sex with or what he did. Their concern was that he was treating his wife as if she was a black woman. He was devaluing and disrespecting her by letting this black woman correct her and by letting everybody in the neighborhood know, because he went off to Indiana, where you could get easy divorces at that time, and sneaked off and got himself a divorce and a settlement that he'd get all the property so his wife wouldn't get anything, and came back. So he didn't want to take care of his wife, which a gentleman would do, and he wanted his wife to be seen as underneath a black woman publicly. So the court was mad at him and said, you know, gentlemen, you are acting out of the frame of the story of what you're supposed to do. Yes, have the black woman, but don't disrespect your family openly, even though it is known to everyone. And think about whose story didn't get told there. Nobody was interested in Sally's story. The heck with Sally. The stories we were talking about was Mr. Turner's story and the story of the wife and everything else. Sally was an object to be acted upon. Who knows why she did whatever she did, and nobody cares why she did whatever she did. So whose story gets included? Whose story gets included? And the pig farmer's daughter's story doesn't mean, now, as when I told it to somebody, a historian friend of mine, his first reaction was, my gosh, again he said, my gosh, that proves that, you know, these people were not racist, you know. After all, this man got off, you know. I said, in the first place, we don't even know whether he raped her or not. I mean, leaving that aside, we don't know. But in the second place, this wasn't about him. This had nothing to do with that. This was about class, it was about paternalism, and it was about elitism. And who would call justice having to be the white man's boy? Now, how is that justice? Or having to be anything? That's not fairness, and having your story never told. Now, the interaction between stories and the interpretation of legal rules is a process. We change the law not by focusing exclusively on the rules, but by changing the experiences and eroding the myths and stereotypes that underlay each person's stories. In this way, we can make everyone's stories count. If we want to ensure justice, we must give voice and power to previously silenced narratives, remembering that what the law does is a part of everyone's personal stories. Otherwise, the law has no validity and is an illegitimate exercise of power. But changing the stories, that is, how do you change the stories, requires action, not just analysis. And one of the most disheartening things is to work very hard to change the stories and to work very hard to get people in who have had different experiences. In the case of women, in the case of people who are poor, in the case of African Americans, Latinos, and other people of color, to get them in the system because you think they will bring to the system the story of how, what has happened to people like them, and that they will be able to have a perspective that they can share with other people, like Thurgood Marshall used to when he was on the Supreme Court, when he would sit around and tell the other justices about the way how it was and what happens to people and so on, so that they enlarge their perspectives, open the window, let in new story, open the doors. That's what you hope when you want to make change. That's why it's even more distressing to have someone who you get in come in there and say, well, I don't have any story, you know. My story is just like the story of the people who are already here, you know, and that makes it hard. But changing the stories requires action, not just analysis. Take this, for example. The 14th Amendment has been on the books since 1868, but was used primarily to promote property rights rather than to protect human rights. It was World War II, the threat of Nazism and communism, which produced and put in vogue alternative stories, which in part created the context which made it possible to have Brown against the Board of Education. But think about this. The Brown case, while an important landmark and came out of this new set of stories, didn't go far enough. How do we know it didn't go far enough? Because in the Brown case, the story went only so far. Some change, but not all the way. Because it didn't say desegregate the schools now. It said what? With all deliberate speed. I mean, since when did a court tell you to do something and then say, well, do it with all deliberate speed? Hey. It meant that the stories were changing, and they had changed. Then you got the civil rights movement, which made it possible for new stories, change and more use of stories. On the issue of gender, the women's rights movement did the same thing, and the gay and lesbian movement, which evolved from that kind of context, is working to make different stories on that subject. What we have to do to secure justice is to undo the old narratives and to replace them with new ones. And to do so, we must understand the importance of storytelling and reconstructing history and making law. And we must be receptive to the alternative stories other people tell. And what I am doing is trying to draw America's attention to storytelling and to expand the stories we consider. Still, I didn't tell everybody's story, because there are always some more stories out there. And this one is on race, gender, and class, and its most graphic expression, sexuality. Because with sexuality, we have stories of what is forbidden and permitted. And what is forbidden and permitted sexually lies at the core of self-definition and definition of the other, who has power and who is denied power. So the disputes discussed in this book are real. They're not made-up stories. They're not fiction. And they show how the stories have influenced the law. We are changing them, but in many ways they remain the same, and trying to change them is hard work because backsliding, my friends, is much too easy. Thank you very much. Does anyone want to ask me anything? I could take a few questions, I guess. Is that all right? Those of you who are in charge. Yes.
You mentioned race, gender, and class. Does culture play into your telling of stories at all, or to what degree, if so? Thank you.
Tell me what your definition of culture is, and then I'll answer the question.
Well, I could say it like the Temptations say it, the way you do the things you do.
Oh, yes.
I mean, that might be
That
too
is-
simplistic, but it certainly does cover it, certainly.
Yes, well, that is exactly, I would say that what is embedded and imprinted based on the factors that I talked about race, gender, and class. There are any number of factors that play into this. And so we're talking about, yes, different cultural stories, different perspectives, different ways people do the things they do. All of that plays into how the law is made and what people expect and what they see. Yes, it does. I mean, whether you see somebody, someone told me the other day that there are some judges who look down and they see a youngster who comes into court having done something like his first theft of a bike or something, and they look down and they see some guy with his hat turned on backwards and his pants down and speaking in a certain way, and he immediately thinks predator. You know, the judge thinks that. Because the way he does whatever he's doing is not the way the judge thinks people ought to be doing whatever it is they're doing. And so there are all these cultural frames of reference too, and I would say that the same analysis would apply. Yes.
I have a question. It's a little different from what you're talking about. But here recently we had the incident in Colorado, and I noticed that on one of the newscasts, when it first came on, one of the news said, well, how could this happen in this area? And it just really turned me off. How does that impact? How does that story, does that reflect what you're talking about?
Well, the newscaster obviously had a story, a frame of reference, which was things like this happen in places that people like that live in, certain kinds of people, you know. And so therefore we don't expect things like this to happen in places where people like this live. And so he had deeply embedded in his consciousness, as do many Americans. And you know how we can tell what stories people believe in terms of consensus? Now we have polls that will tell us what people believe. Like if people think, you know, African Americans are less patriotic and lazy and whatever they think. And the way that people of color define each other in polls and the things they say about each other. So what that newscaster was doing was simply expressing his take, his story. So this is his exception out here. And how do we account for this? We've already, in his view, accounted for those other people doing that, but now we have to account for this. It's like the comment I heard made that the reason why you couldn't do anything in Rwanda about the Tutsis and the Hutus and the massacres there was because you expect things like that in Africa, you see, which is a story, see. But you need to do something over here because, you know, with these people, we don't expect anything, you know, to happen. And so there's hope, and we can save them, but those other folks, you know, their story is that they're unsaved. So that's what he was expressing. He needs to get, you know, broaden his perspective and open up his mind to new stories. Yes?
What can we as college students right now do to change the stories in order to change the laws?
What you can do is, first of all, realize what I said about the law is more than the technicalities. Although the technicalities, that's a story too. That's the story we're supposed to believe. The technicalities, that's what it is. That's a story, okay? What you can do is, if you understand what I'm talking about, there are three ways basically to make change. One is to make change by something you do as individuals to make clear to people that you know what the deal is. The other is to organize with other people who believe similarly to say loud to judges, to the legal system in general, and those who run it wherever you are, that we understand why these things happen and why decisions are the way they are, and we want you to broaden your perspectives. The other way is to do it politically, which is to act, to vote for people who will put other people in place to hand down decisions in these cases. Because the ideal thing would be, the goal ultimately, in terms of the legal system, would be to have most of us see things the same way, so that everybody's story would be in the mix, and so that we all understood, you know, our take on everything included everybody's take. And then we would have the judge as sort of the traffic cop who would sort of sort all this out, and everybody's take would be included. no different angle of vision depending on different experiences, so that people don't have experiences of police who do bad things or police who do good things, or differential experiences on the basis of race, sex, culture, whatever it is. That would be the goal. But we're not there, so the only way you get there is to insist that they be included. And also, when you work hard and vote and do things like that, to get folks included as decision makers, and they in fact do not convey the experience, then you have to call them on it. I mean, that's basically what you have to do. So part of it is understanding, and then also training yourself so that you can become part of that apparatus once you understand, so that you can become part of it and do it. That makes sense. You know, people talk about jury nullification a lot. You know, why are these juries not convicting these people? The judge told them to convict that guy. And they said, so what? The reason why they didn't is because their story was, they had a story which told them this neighborhood is targeted and this is happening and this came from here, and they were looking at the, quote, facts in light of their own experience. If their neighborhood wasn't targeted and they had no such experience, they wouldn't be sitting there looking at it based on that experience. They'd have some other experience. And so you have to change the circumstances of people's existence. If everybody had the same life chances, okay, then you would have people who had similar stories. Yes?
I have a question, Dr. Berry. Many years ago, I was looking to the Virginia court just by curiosity, and came upon the bastardy laws, they call them. And I wonder, in the light of your research, if you have any comments on these laws where the wife or the woman was required to present evidence that is really strictly impossible to prove that this child is this man's child. As I read them, I said there's no way with the requirements that any person can have this proof. What's the historical basis, if you have any?
Well, there's a section in the book on such cases that has to do with child support and other what I call consequences of sex, and how it plays out. How it plays out differentially. And child support and bastardy is one of them. And historically, the whole purpose was that the community didn't want to have to take care of the children, you know, as a result of such unions. And the woman was, of course, respectable as a result of this having happened. So you identify the father, so the father could, in fact, take care of the youngsters. In the absence of genetic tests and DNA and all the things that we have now, with tests to be taken, they would do things like, and I talk about some of this in the case, the child resembled the man. You know, they'd bring the child into court and he'd be there and they'd pass him around and they'd all look at him and they'd look at the child and they'd try to see, you know, or they'd say, well, he's pigeon-toed and he's pigeon-toed, whatever. He lists to one side and so does the baby, you know, or something, to try to figure out whose baby it was. The whole purpose was to try to find, to make people take responsibility for the consequences of the sex. And then the proof on the other side would be, the man would often argue, and I have a case like that in there, that, well, I'm too old to be having, I can't have, you know, it's not possible. And they would have unscientific, in the absence of Viagra arguments, you know, about what was possible and what was not possible. Or I'm too young and I couldn't have done it, you know, it's not possible. And so all of these defenses, gradually with science, and with the development of all these tests and things. But the principle is the same today as it was then. They forced, under those laws, the woman to identify the man who was responsible. You may know that in the reform of the welfare legislation nowadays, it requires people to identify the father in those cases. But that too has to do, all of that has to do with one, stories about how these relationships develop, what happened, who's supposed to do what, and what a father's responsibility is, what a mother's responsibility is, and what society's response is.
From a historical perspective, it seems to me that our system of justice, system of jurisprudence, has been one of the most unjust facets of an unjust society system. Do you consider that we, let's say for the last half of this century, have made significant progress in our system of jurisprudence?
In the first place, I don't think our system of justice is any more unfair than a lot of things that happen in society and the economy. I think it's, they're all about, have the same degree of fairness, unfairness, and so on. I think that they in fact relate to each other, because justice takes place or injustice in a societal context. It is not divorced from the societal context. The second thing I would say is, yes, we have more of what I would call fairness and inclusion of different stories now than we had 50 years ago. To be sure, most of the people who have been appointed to our courts, who come from groups that were previously locked out, whether they're women or people of color or whatever, do try to include perspectives and to educate the other people who are in the system with them about these perspectives. They're not always successful, but they try to do it. And as far as the legal system is concerned, there are blacks now and women who are in law school and write on law reviews and do things like that. And so there's more opportunity to have an influence today. There's more changing of stories because over historical time, there has been change. The problem is that, of course, just like in society, there haven't been enough, and also that the stories we have in our heads about the law sometimes keep us from insisting on more change. For example, someone said to me, how can it be that the law takes into account people's views? I mean, that's not possible. And that we should understand that people have views, judges and so on. Well, if judges didn't have views about things, why is it that every time a president nominates a federal judge or a Supreme Court justice, people have big debates about what do they think about abortion and what do they think about this, or why is it that in particular administrations they say we're going to have a litmus test. We're not, getting anybody who doesn't believe X, Y, Z, or ABB. Everybody knows what I'm calling stories is correct. It's just that we have a story that we're supposed to pretend we don't know what we do know. And in the legal system, they let us. I was thinking about the debate over clerks for the Supreme Court that the NAACP and others have been fighting about trying to get more inclusion there, because we really need some new stories in that input, because clerks are very important. And when you heard the justices respond, you would have thought, if you didn't know any better, that there's some kind of magic about, they have to come from certain schools, and it's important, and there are certain, standards, and they come from certain places. And if you didn't know that for most of our history, the clerks came from the schools that the justice went to or taught at or something, and that many of them let the professor, who was their major professor there, pick who the person was, and that there was nothing in particular that meant that you couldn't have other people to do that. And so you get the same tired old stories over and over again, and we're supposed to be afraid to say anything because, the law is mysterious and it's technical, and we're not lawyers and we don't really understand all this stuff. And that's crazy. It's plain common sense, actually. Yes?
I wanted you to relate to us in the course of the research, in your estimation, what represented the most salient example of the atypical, the most salient example of atypicality or unpredictability in a story. In essence, are there instances or were there instances where the marginalized man or the marginalized group's story was told in contrast to what was predictable or what was expected?
Well, it depends on what you call marginalized. Some people would say that in Simpson's case, O.J. I'm talking about, his story got told and he was marginalized because he was black. Of course, he's rich, so that's another different, story. But in most of the cases that you find, while it appears that the marginalized person's story is getting told, it's very difficult to, when you really examine it, on the surface it may sound like, their story is getting told. Oh boy, isn't this great? And then when you look to see what they did and why they did it, and it's not so much about who wins and who loses, because the guy in The Pig Farmer's Daughter got off, even though his story wasn't told. But he got off for the wrong reasons, as it were, if the goal is to do something else. So that most often the marginalized person's story gets told when it is in the best interest of the person who controls the system. the persons who control. When it's in a court, I'll give you an example of what I mean, so make it clearer. I found all these inheritance cases of black women and their children, all the way up through the 1930s, 40s, all the way up until Loving got decided, which made interracial marriages okay, where black women who were concubines of white men, going all the way back to the end of slavery, and their children would inherit under a will from this white man who was the father of the children and who had this relationship. Well, the woman would inherit. And so some people say, well, see, that's the case of the marginalized woman and her children getting the money. So they won. And so that's one of those cases. And at first I thought that. And then I began to look more closely. And I discovered from what the judges did and what they said and what went on in the court, they weren't interested in that woman and those children. They were interested in implementing the will of the white man who wrote the will. The whole discussion was about, there's a principle in the law that you, which is a story, you implement the will of the testator, the person who wrote the will. You're supposed to implement what they wanted to do with their money. Okay, that's a rule. So they would say, well, what did this man want to do with his money? He wanted them to get part of it. Okay, well, if he wanted them to get part of it, then fine, they can get part of it. As long as he is supporting his own white family, and as long as he's not disrespecting his own white family, if he wanted to give some money to raise some cats, we would say fine. Or some money to the zoo, we would say fine. So if he wants to give these folks some money, we don't care. It's nothing to us. Cats, zoo, these people, children, whatever, That's what he wanted to do. So again, they become what? Objects. It appeared like they were subjects, but they really were objects. And so you have to watch that in the analysis. And that's not surprising because law is supposed to implement the will of the powerful in any society unless you make it not do it. Yes?
Have you given any thought or analysis about the, well, not just the accusations, but the actual, the position of the accusers of President Bill Clinton, whether you're talking about, a low-level state worker like Paula Jones or a campaign volunteer like Kathleen Willey or a campaign supporter like Juanita Broderick, childhood friend Dolly Kyle Browning. Do you, the power relationship to me seems very significant and exploitive. And then like Christopher Hitchens, for one, has drawn a comparison to the bombing of civilians, women and children in Afghanistan, Sudan, Iraq, and even now Serbia, as far as, tying it in with the sexual accusations and the legal proceedings. And then also, I think just the power at work here, a dominant force over someone in a weak position.
I always find Mr. Hitchens amusing and witty, but I think going from, Paula Jones to Serbia and to women being raped or whatever, bombed or whatever, is a stretch. But I'll answer the general point. You are correct that it's like the layers of the onion, as I started out with some of these other cases, thinking about them. On the surface, it would seem very much analogous to talk about the differential power relationships involved in the cases of the women you cited and the way their issues are treated compared to the way the president and his status. But when you remove the layers, it becomes more like the Mike Tyson rape case, which I mentioned in the book. Remember the black woman who claimed that Mike Tyson had raped her? Desiree, I think her name was. And here you have a case which first looks like, they took her case seriously because the law takes black women seriously, and the law convicted this black man because he raped this white woman, and that was serious. That would be the first. But when you really started to analyze it, what you saw was that you had the devaluation of black women pitted against the idea that he was this powerful black man, and that he was supposed to be the embodiment of the, sexually consumed, violent, whatever it is, black man, and needed to be taken down a notch, if you know what I mean. so that you had more than one variable involved in it, and it becomes very complex trying to sort out which one had the greatest weight. Based on the history of it and the way it was put together, I would think that the last set, because most often the claims of black women are devalued and they don't get anywhere. And so the fact that it was Tyson and the fact that you have him identified in this way, I think caused that to happen. But in any case, on the Clinton matter, so therefore I don't know whether it was cutting him down a notch, so to speak, or whether it was simply that we should look at it as the differential power relationships. But it's a very apt question, and it does require very careful analysis. I didn't deal with it in my book because it's not a state appellate court case of the kind that I was looking at, and didn't come out in my sample for the 20th century. How many more should I take? Yes.
I'm a little concerned about someone saying we've come so far. And it invariably comes from a middle-class person who's living better than their mother or father. You're working in the Civil Rights Commission. I think there have been some changes, such as there have been changes for white folks. But I am concerned about the subtleties and how people can say we're doing so much better when in fact there are glass ceilings. And I'm sure you've got some data that can show we haven't done that well.
Oh, absolutely. There are glass ceilings and adobe walls and sticky floors, too, that you can't get up off of when you get these jobs. They most certainly do exist. No one, none of my enemies would never, my political enemies would never accuse me of saying, we've already overcome, so, you know. But I'm usually pessimistic about such things. But I think that by comparison with the opportunities that my mother had available to her, that there are more opportunities available for, my mother couldn't go to high school because there wasn't any high school for Negroes where she was, okay? And she's a lot smarter than I am, you know, and could have been head of, you know, General Motors or some doggone thing if she wanted to. And so I think that in terms of and I also think it's wrong for us not to emphasize ourselves how much we did to make that change. We should not devalue the hard work and the people who suffered and who died to make the change that occurred. Because if we pretend that nothing happened, then they died in vain. And they didn't. So the point is that while some change has occurred, progress is still differential, yes. And progress for large numbers of us is still very slow in coming, and sometimes it looks like it's not coming at all. And in particular, we had a hearing a couple of weeks ago on the crisis of young African-American men in our cities. And that's a major crisis, and there are other crises in the society. But the point is that there has been some change. Many state Supreme Courts have women members and African-American members and some Latino members, and when they didn't, you know, 50 years ago or 40 years ago or even 30 years ago. And some of them are people who do try to bring perspectives to bear, and some juries do include people who have different stories and who are able to get together to try to have an impact on that. And sometimes it does look like we're going backwards, but the point is that there has been enormous change, and we should be proud of the change that has happened and try to build on it and be optimistic and never be despairing and depressed, because that way consigns us to retrogression. Thank you very much.